Good morning, Marty.
Good morning. Did you not get a link?
Okay, Jennifer just said to check my junk folder, and that's where everything was. I don't know
Okay.
because we changed our email addresses.
Yeah, sure.
Yeah, everything was in my junk.
Okay. And then I misunderstood this morning. I'm working on the handout link right now.
Okay.
Yeah, trying to get it uploaded so I can put it in the chat. But if not, it'll go out in the follow-up email
I
for
just thought
sure.
I'd send it to you because I
Yeah,
remember we'd put that together for this presentation.
yeah, it's great. That's really, I mean, that handout's very helpful.
Yeah, I
Seriously.
think people seem to like it.
Yeah.
So how are you doing?
Just keep moving forward one step at a time.
Plugging along.
My my mother I'm sure I've said this before, but my mother ended up in a nursing home
Oh, man.
abruptly, and I've spent 3.5 out of the last 5.5 months out in California
Oh my gosh.
on 3 trips. The last trip was for 6 weeks, trying
Mm.
to take care of her house and deal with um, lots of sibling issues.
Oh, wonderful.
Yeah, they're it's one of those difficult things because I'm the only boy, but I'm not the oldest child. I have
Hmm.
two older sisters, and I didn't know they didn't. I didn't know they didn't know that I was the executor of her trust, and so they found out, and they just
Not happy about it, I'm sure.
they are not happy about it. They have just stopped doing anything to help my mom, stopped doing anything to do anything.
Oh
They're
my
just,
gosh.
yeah, just they're really just going to and my poor mother, she's although she's doing very well in the nursing home, she loves where she's at, which is a blessing, but she's just beside herself in regards to you know all of the ugliness and
Yeah.
and everything. Yeah. So, and that's one of those things that it came up because she ended up in the nursing home. But boy, you'd sure rather it come up after they're gone, so they don't have to see the ugliness.
Right. Right.
Because it's just, yeah, it's tearing my mother up. It's really
And it's a lot easier doing it for a living than it is living it. When I went through it with my mom, that's the same thing. I'm like, okay, I help people all the time in this area, but when I had to live it, it was a whole different world.
boy, it is, and we had my niece's wedding when I was out there last, and um, I went to the wedding, and there's a whole bunch of other dynamics going on too, but you know, they just they won't speak to me. They have not talked to me in 6 months,
Oh my gosh.
and they're just and I had nothing to do with this. My parents years ago asked me, or told me that I would be doing this. I didn't know, they didn't tell them.
Yeah.
Um, and I did. I was told that they had gotten a copy of the trust.
Hmm.
So I don't know if they got a copy and just didn't read it, or or what. But yeah. So they just weren't going to lift a finger to help with anything in regards to an estate sale and the house and all of that kind of stuff. They're just, and
Oh my
okay,
God.
then you can just do it all yourself. so,
Golly.
so
Yeah.
guess what? I'm gonna do it all myself.
Yeah. Oh my
So,
gosh. I'm so sorry.
no, it's just the way it
Okay.
goes. It's just I bring it up. It's because it's the reality of what we live in in what we're talking, all the things we talk about.
Yeah. I tell my every family is this way. There's very few families that are cordial. There's more families that aren't than are. And I, tell the story about my middle sister, I'm the only boy and I'm the baby. My middle sister, I think hated me from the day I was born because I came into the world and ruined everything. And
Of course,
she and I
yeah.
never really got along, but when my mom when I moved him out from El Paso to Dallas and we're taking care of him because my sister was sickly also. She had severe Crohn's disease and
Oh,
COPD
I
uh,
see.
and so when I was taking care of them, all of a sudden I look at my mom's bank account and it's gone. And I've come to find out that my sister spent about $25,000 on Amazon of my mom's
Wow,
money.
wow,
And when I approached her about it, her response was, "I wanted to make sure you didn't get it." And so
yeah,
she spent all my mom's money that was needed for, caring for
yeah,
her
yeah,
because she didn't want her little brother to get it. And I
yeah,
said, that's sad, but that's family dynamics and we all deal with them and it's a shame. It's really a
yeah.
shame.
Yeah, yeah, and William, I appreciate your comment. I did see that. I sorry that you have to go through it because I'm going through. Like I said, I'm going through it, and it's not. It just isn't pleasant at all. But
Yeah.
the yeah the yeah it just is it really is a shame, and I will guarantee you it's taken my mother's health has has taken a toll on her
Yes.
physically,
Oh, it
and
does.
and 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 here she's already ended up in a nursing home kind of pretty abruptly. She's very cognitively capable, and
Mhm.
um, and and I have told my sisters so many times over the years, and and how much I appreciate all they've done for my mom. And they've done a lot. I mean, I have, in all due respect, they have done an incredible amount for my mom because they live there.
Mhm.
Um, and and um, I appreciate it. I do. I really appreciate all they've done. But they're going to show her and show me how unhappy they are about the way things
Mm.
are. So
Mm-mm-mm.
it's it's tough. Yeah. Um,
Well,
and
can you let me share my screen
I,
there?
I'm sorry I did not do that. I was, you know, do you want to go in? I don't know if you can do this. Can you go in? Do you want to change your name to Jen? You're
Oh
going.
wow,
It's
I didn't realize my name was Jennifer.
yeah, it's showing you as Jennifer.
Let's see, how do I change that? That's the
That's
settings.
I know there's a way to do it. Gosh.
I'll see what I can find. I'm looking at it right
It, it's it's not vital, but I just didn't know if, and I just gave you the power,
now. Okay.
and I do realize it's it is that time. So sorry, y'all. We got carried away with personal um, tribulations of actually things we actually talk about and have um, these webinars about. And one of them is family dynamics, and we just happen to be living it in real time these days over the last 6 months, and so it you should be able to share your screen.
Yeah, I'm just trying to see how if I can change the name. I don't know if I can.
Yeah, let me see if it'll. Here, I can read it's. Hold on, it says I can rename you.
Oh, okay.
I've never done it before.
I've never done that either.
There you go.
Oh, that was easy enough.
That was easy enough. I've never done it before. Sorry.
Let's see if I can get the screen up. Yeah, I think we got it.
I think we do.
Should be seeing the first slide.
You got it. You got it. And if you're ready, it's that time.
Okay, let's go ahead and talk about CEUs.
Okay. Well, welcome everybody. My name is Marty Mascari. I'm a contractor under the North Central Texas Area Agency on Aging and Aging and Disability Resource Center (ADRC) in the North Central Texas area. It is under the umbrella of the North Central Texas Council of Governments, and we are blessed to have our friend at Haiman Law, Fred Haiman, here today to talk about what happens when the first spouse passes. It talks about, we're going to talk about a lot about what happened when someone passes. And so before we do that, I wanted to go over the CEUs. We're providing complimentary CEUs for licensed social workers and licensed professional counselors within the state of Texas. We're also offering a complimentary certificate of attendance as well. If you have a different license in Texas, or you have a license outside of Texas, you're more than welcome to go through the process and get a certificate and submit it to your jurisdiction. But please note, there's no guarantee that they'll take it. But I will tell you, I've had people, even from out of state, that have told me they've been able to use them. And I've also had jurisdictions reach out to me for additional information on the webinar so that they could determine whether it met their minimum requirements. So if you would like to do that, you're welcome to do that. Today's webinar is worth 1.5 hours of CEU credits. You must be on for the entire live webinar and the Q&A until 11:30. You're not required to stay past 11:30. I realize you have other commitments. Many times there's lots of questions, and so we end up past 11:30. You must complete the Google evaluation survey. It should pop up as you close out of Zoom today. But if it doesn't, you'll receive the link to that in the follow-up email that will go out, should go out tomorrow. And I'll say should because it can change a lot for a lot of reasons. But it should go out tomorrow. But please note, the Google evaluation survey is not only required for the CEUs, but it also gives me and tells me that you want CEUs. That's where that information comes from. So you must complete the Google evaluation survey. And actually, to be honest with you, it's a requirement for CEU under the jurisdiction or the law that pertains to CEUs in the state of Texas. The survey link, like I said, if it'll go out in the email probably tomorrow if it doesn't pop up from Zoom. The survey will be open for about a week, a little over a week, and give us about a month to get us the surveys out to you, or the certificates out to you. They'll go out by email, and we are behind right now. We've finished August. We're really just starting on September's webinars. So please hang with us. We will get them caught up. I've been out of town a lot, and it's a very difficult thing for me to do from my laptop. It's one of those things I've almost got to be in my office to do. So I apologize for that, but I'm working on getting caught up. Fred, I'm going to turn it over to you, Fred Haiman with Haiman Law, and let you have it.
Well, thank you, Marty. I appreciate that. Well, this morning we're going to talk about, my loved one just passed away. Now what? And this is a presentation about the estate administration process, which is the legal process we're going to talk about that you have to go through when someone dies. But more than that, I'm going to add a lot of stuff into it, and we're really going to talk about things that need to be thought about and done from the very beginning of the minute the person passes away until the end. I have put together a handout that Marty will be providing through the chat at some point throughout the presentation, but it's a handout, and it lists about 40 things that you need to consider and need to do as you go through this process. Some of you all have probably heard me before. I've been doing these presentations with Marty for quite a few years now. I am now, I used to be with an organization called Haiman Hogue. My partner and I separated the firm in July, and now I'm Haiman Law. But this is the line of work that I do. I do estate planning, wills, trusts, probate, guardianship, and elder law. And I tell you that because as a disclaimer, this presentation is not selling me or my firm or trying to get any business for me and my firm. It is strictly an educational presentation on the estate administration process. So let's go ahead and just dive on in. What exactly does it mean when we have to, when we hear the term administer an estate, or you hear the term probate? A lot of people have heard those terms, but they really don't understand what they mean. Administering an estate in simple terms means that once somebody passes away, we have to collect whatever they had, collect their assets, collect their property, whether it be tangible property, whether it be a financial property, whether it be intellectual property, whatever that person owned, we have to collect it, we have to manage it, and then we have to distribute it to who's entitled to it. And who's entitled to the distribution is dependent on quite a few things, but the main thing it's dependent on is whether somebody did an estate plan or whether they didn't. So in theory, it's gathering assets, managing the assets, paying debts, and distributing the assets. But in all actuality, there's a lot more to it. So let's start right from the beginning. When somebody passes away, immediately after the death, there are certain things that have to be considered. A lot of these, as you look through them, you'll say, oh yeah, that makes sense, but you don't think about it when the time comes. And that's why I do this handout, because it's nice to hold on to and to share with people when they're going through it. Because as we were talking before the presentation, Marty's going through a situation with his mom and his sisters, and I've gone through it. And my mom passed away in January of this year. And you even if you do this for a living like I do, when the time comes and the emotion is there, you forget everything. And it's like, I've even had doctors tell me, I went to med school and I know how to do this, but then when my child got sick, I felt like I lost everything and I didn't know what I was doing, because emotion affects everything. So like when somebody first passes away, one of the first things you need to think about is organ transplant. Is this person an organ donor? If they're an organ donor, there's a lot that needs to be done immediately because time is of the essence. There's arrangement for transporting the body. There's locating friends and family and acquaintances and informing primary care doctors or any specialty doctors this person has. What if the person has pets? arranging for care of pets or arranging for care of dependents, children, or I have a lot of cases where a person passes away and they've been taking care of a special needs person and their guardianship of that person or whatever the case may be. What needs to be done with those people and securing valuable assets of that person. I tell the story of when I was practicing law in El Paso many years ago. I got hired by a family to do a guardianship for their 102-year-old aunt. The aunt, as we were going through the guardianship, she passed away. And I get a phone call, a panic phone call from the family who lived in Mississippi. And they call and say, you know, our aunt's passed away. We're afraid people have keys to her house, and we're afraid people are going to get into her house and steal all her stuff. And I said, okay, if you give me authority, I will go up to the house, I will get a locksmith, and I will change all the locks. And of course, they did. So I went up there and I got the locksmith, and we're going through all the process of changing the locks. When all of a sudden I hear these sirens. And next thing I know, I see 3 police cars come flying up the street, screeching into the driveway of this house. And I step out of the house, and luckily I was a police officer in El Paso before I was a lawyer. And so a lot of the El Paso Police Department I know. And as I stepped out of this house, I see an officer jump out of his car, and he sees me and I see him, and he stops and he says, "You don't look like a burglar." And I said, "You're darn right I don't look like a burglar." So he called all the officers off and told them, you know, it was a false alarm. There wasn't a burglary in progress, but it made me realize that I screwed up because before I even went up to that house, I should have called the police department. I should have called the station in that area and said, "Hey, I'm going to be up at this house. I'm going to be changing the locks. And if any of the neighbors call in a burglary, it's not a burglary." So these things you don't think about when those times come, but those are things that need to be taken care of immediately following the death. Then we have certain things we have to do before the funeral, like locating final expense insurance policies or pre-need policies. What did this person do to prepare? Did they contract with a funeral home? Did they already pay for their funeral needs, or did they have an insurance policy that is supposed to give money for those funeral needs? You have to locate all their important papers, because a lot of times the funeral homes are going to ask, do you have birth certificates? Do you have any military papers, marriage certificates? They need all that. You need to file insurance claims to obtain the benefits if it's an insurance policy that's set to pay for the funeral arrangements. Or you need to get with the funeral home, and a lot of times they'll do it and they'll take that responsibility. And then if the person's a veteran, what about veteran arrangements? What did this person want to be buried at the National Cemetery, or did this person want to be cremated and their remains placed at the National Cemetery? So there's a lot of things that need to be determined and decided before the funeral even takes place. Then we look at the funeral itself. One of the things that I think is one of the hardest things to do is to write somebody's obituary, or to be the person at the memorial service or at the funeral who is in charge of giving the eulogy. And I always ask people, have you ever thought about writing your own obituary? And a lot of people think, well, that's kind of morbid. I don't want to do that. I don't want to, we don't want to think about our own death, more or less talk about it or write something down about it. But honestly, that's one of the best things you can ever do for your family, is even if it's an outline form, is to write down some of the things that they can say at the funeral. Because when the time comes and the emotion is there, trying to think about, I mean, my dad, I did it for my dad. But when the time came for me to give the eulogy for my dad, it was like, oh my gosh, I don't remember. There's so much I'm not remembering. And if I would have, you know, had some notes, even myself, or if my dad would have left something, it would have made life a lot easier for me. You have to carry out the memorial service, the funeral arrangements, whatever has to be done, and arrange for the the grave site, or if they're going to be cremated, where their ash is going to go, and do we need a headstone? And then after that, obtaining the death certificates. And that takes time. A lot of people think that death certificates are a rather quick process. It's not. It's typically about 30 days. A lot of times the funeral home or whoever does the arrangements will assist in that, and they'll get them for you. Because you need that for almost everything that it takes to administer the estate. And then the last one is finding a will or a trust or any other estate planning documents this person did. Did they do them? And a lot of times the family has no idea. They have, did dad do a will? Did dad have a trust? Did dad, what did dad have in place? And so you spend your time after the death going through houses, going through offices, going through drawers, trying to find to see if this person even did anything. So all I can say is, a lot of, and you probably heard this before, organization is the key to making life so much easier for everybody. The more organized you are, the easier you're going to make it on your family. And so, do you have a will? Does your family know you have a will? Do you have a trust? If so, do they know where it is and all that kind of stuff? And as Marty was pointing out when we were talking, as we were getting ready, let everybody know what the details of that are before the time comes. Let the family know, yes, I have a will, and I've named this child as the executor. I've named this child as the first alternate. I've named this child as the second alternate. The beneficiaries are the children. So as long as people know the details of it, it makes life a lot easier. Now, a lot of families say, "Well, I don't want to share all my, I'm a private person. I don't want to share my finances." Well, you don't have to do that. You don't have to share the details of what you're giving people, but you can share the details of what you set up and where to find it when the time comes. So what is probate? Probate is a term we hear all the time, but the reality is probate is a rather simple definition. It is a court supervised process of settling a person's estate, whether they died with or without a will. So you go through probate whether a person has a will or whether they don't have a will. Now, you don't go through probate if a person has a trust and the trust is properly set up. So one of the biggest parts of my practice is doing trust for people, because as we've gone through time, people are realizing the benefits of a trust. And we'll get to that in a minute. I'll talk about that a little bit more, because one of the things we're going to talk about before this class is over is ways to avoid probate and avoiding this process. But if a person dies without a will, or they die with a will in Texas, you have to go through probate if there's property that needs to be administered. So what determines probate? Probate is determined by the laws of the state of Texas and the type of property that were held by the person who died. So people ask me, can I avoid probate? Yes, you can avoid probate. Depending on what you own and how you own it, then there's certain things that can be set up to avoid probate. But the law of Texas decides. There is a big giant book called the Texas Estates Code. And the Texas Estates Code governs everything that goes through probate court. Now, probate court in large counties, heavily populated counties, those counties have what we call statutory probate courts. Those are courts that all they do is probate. That is their entire job, is just to do probate matters. Now, those are counties in Texas like El Paso County and Bexar County and Travis County and Harris County and Dallas County. In the Metroplex, there are 4 counties that have statutory probate courts. It's Dallas, Tarrant, Collin, and Denton. and those courts have their own special probate court. Now, small counties outside of the Metroplex and outside of these bigger cities, they typically don't have their own probate court. The county court or the county court at law handles probate matters. And those county courts and county courts at law are what I often refer to as kind of general law courts, because those courts might be handling criminal cases one day and DWIs and that kind of stuff. And then the next day they may be handling family court divorces. And then the next day they may be handling probate courts. So it's difficult for those judges because they have to know many areas of the law. And because of that, sometimes it's difficult handling a probate in smaller counties because the judges aren't up to speed on exactly how it goes. Where when you're dealing with a statutory probate court, that's all they do. So they know exactly what needs to be done to run them through. Now, the courts are determined on the judge, and some judges are good and some judges are not good. And I know if there's judges out there, they're going to not want me to say that, but that's the truth. It's the truth in attorneys. It's the truth in everything. You've got good ones and you got bad ones. And I've been in probate courts where it's so simple that the judge walks you through it. And I've been in probate courts where the judge made it hell. And it made it difficult on the attorneys. It made it difficult on the parties. So my attitude is, if you could avoid probate, avoid it. So, okay, what is the probate process? First, there's really two big steps. The first step is to determine the person's dead. And I know that sounds kind of silly, but there has to be proof that the person passed away. Now, I've been involved in cases where a person disappeared and there was no proof whether they passed or not. And I haven't had one in a while, but I think there's a part of the law says if they're not accounted for a certain number of years, then you can proceed with probate. And for some reason I want to say 7 years, but I'm not. Don't keep me on that. But you have to be able to show that the person passed away. And so part of the prove up is proving that the person passed away. The court wants to see the death certificate. And then the court authorizes the administration of the estate. So the court proves the death. They determine whether there's a written instrument, a will or not. And then they authorize whether this estate can be administered or not. So probate is almost always required if the deceased person owns these three assets. The first asset is any asset that is in the sole name of the deceased person. And what I mean by that is it's an account in their name only. It is a titled object in their name only, or a deeded object in their name only. And with accounts, as financial accounts, it's not only in their name, but that they did not leave a beneficiary designation, or what we often call a TOD, transfer on death, or a POD, pay on death. So if I have my checking account and I'm the only one on the account and I've not listed a beneficiary TOD or POD, then that bank account is going to have to be probated. Another piece, and this is the biggest one, number 2, is if a person owns real estate. Real estate in Texas is owned as what we call joint tenants in common, meaning no matter whose name is on the deed, the people don't own it together. So if my wife and I own a house together as community property, and her name's on the deed and my name's on the deed, we don't own that property together. I own 50% of it and she owns 50% of it. And if we don't do a special deed, if we don't draft something special, or if we don't put it into a trust, if I died without a will, or if I died with a will, my spouse would have to probate my will to administer the estate to transfer my 50% over to her. Now, that is not true for every state. Every state holds property differently. Some hold property as what's called joint tenancy with right to survivorship. And if I remember correctly, I think that's California. California says if I own property with my wife, if I die, it's hers. If she dies, it's mine. And then when we both die, we have to decide who we're going to give it to. But we don't have to do a probate when one spouse passes away. This is a very unique area for Texas. It is an area that says, unless there's a special deed done, when one spouse passes away, the surviving spouse has to probate the estate. And that is why about 10 years ago, the state passed a law allowing for a right to survivor deed or a transfer on death deed. Now, unfortunately, people are not using that deed exactly the way the law had intended for it. Because when the law was enacted, the purpose of a transfer on death deed is to avoid probate between husband and wife. It's not to avoid probate between husband, wife, and when both of them pass to the kids. But yet people are using that deed for that purpose. And I've already been told by realtors and title companies that we're starting to have problems with that because the transfer on death deed was not intended for that purpose. So if you just have a regular deed, which is most deeds that they do whenever you close on a house, you have a joint tenants in common deed. Now I've got a case right now that the deed was done and we have 4 people that own the house. There's a mother and a father and then the daughter and her husband. So all 4 of them bought this house together. And when they bought the house, whoever did the deed wrote their names on it and said joint tenancy with right to survivorship. And then the rest of the deed is exactly like all the rest of the deeds we do in Texas. And so when I got that deed, I looked it up and I found that that one line is not enough to transfer a joint tenants in common deed to a joint tenancy with right to survivorship deed. So what these people were told is not true. So whoever originally did that deed did not do it properly because the law says you not only have to state it, but the deed has to explain that's exactly what you want. That's exactly the intentions of this deed is to do a joint tenancy with right to survivorship. And unfortunately, like I said, this deed doesn't do that. So it doesn't meet the requirements. So you have to be really careful. You gotta hire somebody and work with somebody that knows what they're doing when it comes to real property. One of the big misconceptions I bring up about a power of attorney, and I know we're talking about death, and powers of attorney do not survive death. But yet I get people all the time that think they do. And they'll call me and say, my dad passed away. I need to pay my dad's bills and I have my dad's power of attorney. So I'm going to go to the bank and get access to his bank so I can pay his bills. And I have to tell people, no, you're not, because when dad died, the power of attorney died with him. And if you try to use dad's power of attorney after death, you're committing fraud and you could go to jail. You don't want to do that. So you have to have living documents and you have to have death documents. And powers of attorney are living documents. They do not survive death. So let's talk about the main death document that everybody knows about, the last will and testament. Everybody is told you need to have a will. You need to have a will. And you do. And I say at minimum, everybody should have a will. Why is that? Because if you don't have a will, the government has one for you. Because the government has written the will for people that don't have a will. That's called the Estates Code and heirship laws. So I just recently put up a billboard up near Gainesville, Texas. And I put a billboard up and it says, if you don't have a will, the government has one for you. Do you trust your government? And I did that because I want people to think about the fact that if they don't have a will, they need to do a will, because the government doesn't have your best interest in mind. Now, some people would argue, yeah, well, that's the government's job. Well, the government's job is to take care of society as a whole. They're not to, their job isn't to take care of me and my family. So they don't even know me and my family and or anything about me and my family. So a lot of the laws are governed for general, purposes of how do we do things, and they're not friendly to certain families, especially to blended families, meaning second marriages, third marriages, any marriage that has children outside of the marriage. If you die without a will, the property doesn't go to the spouse, it goes to the children. And that can cause major, major problems. So you at least want a will, but a will does not have any lifetime benefits. If you do a will is no good. It means nothing until the day you die. And then when the day you die, it's not even good then. It's triggered upon death, but it's not good until a judge says it's good. And so people will say, well, I'm named the executor in the will, and my dad died, so I'm the executor. And I tell them, no, you're not. The will says your dad wanted you to be the executor, but the only person that can make you the executor is a judge. And so until we go to court and the judge blesses off on the will and grants you executorship, you're not the executor and you do not have authority to carry out the terms of the will. So in Texas, a will has to go through probate to be effective. And that's why I often call a will in Texas a wish. It's your wishes on paper until it goes before court and the judge grants the wishes. But what does a will allow you to do? It allows you to give away your stuff. So you decide who gets your stuff, not the government. The will allows you to name the person carrying out the executor, instead of the government deciding who it's going to be. The will allows you to do two things that I never ever recommend you use a will for. And that is, it allows you to name a guardian for minor children, and it allows you to put your funeral wishes in there. Now, the reason I don't like that is because a will is not a will until a judge says it's a will. So how much time do you think is going to pass from the time a person dies until the time a will goes before a judge? Weeks, if not months. I guarantee if you have your funeral wishes in there, you're going to be buried or cremated, or your funeral is going to be carried out well before a judge ever sees this document. So why put your funeral arrangements in there? As far as minor children, I've unfortunately seen the situation, and I was a police officer before I was a lawyer. And when I was a cop, I saw situations where there was tragedy in families where parents were killed. They had minor children. The minor children were supposed to go to the aunt. And if the parents are killed under suspicious circumstances or even a car wreck, the police are involved. And if they're minor children, the Child Protective Services is involved. And I've unfortunately seen situations where Child Protective Services has taken custody of minor children pending a court hearing for a judge to probate the will and appoint the guardian. So I always tell people, please don't do that to your kids. If you have minor children, look at setting things up like a trust that avoid this, because a will does not avoid something happening to your minor children while you're waiting before the judge can grant everything. So again, a will is good, but it's not great. But it's far better than no will at all. And if you have no will at all, you have to do what's called an heirship. And the heirship is done either with or without administration, and it's done either independently or dependently. So the easy way to understand this is, if I passed away without a will, my family would have to decide who's going to file the heirship. And when they file the heirship, they're going to have to determine whether we just need to determine who the heirs are, or do we need to administer the estate? Is there property that I can't get access to, or that my family can't get access to, unless they get authority by the court to do it? and quite often administration is needed. Now, independent versus dependent means, is it going to be under court supervision, or is the person appointed going to be able to carry it out without court supervision? Let's say a person passes away and there are 4 heirs. There are 4 children. If the 4 children agree that child number 1 is going to carry all this out, then we can do an independent administration and do it without court supervision. But if one child says, heck no, I don't like my brother, I don't trust my brother, I'm not going to agree to allow him to administer the estate, and one person holds out, then all of a sudden now we have a dependent administration. And the cost of an administration or an heirship with administration isn't cheap anyway. You're looking at $5,500 to $7,500 easy. But if it turns into a dependent administration, you're looking at 10 to 20,000, and it could be more, because everything has to be run through the court. I am a dependent administrator on a case in Denton right now. The family couldn't agree on anybody, so the attorneys came to me and they said, would you agree to be a third-party administrator for us? And I've been working on this case for well over a year now. My administrator fees are probably 15 to 20,000 already, and we're still not done. And we've got now some money that we've got to get the court to determine whether this money was estate money or not. I have to file things with the court. I have to get a hearing, and all of that costs money. So my fees are racking up. One sibling has an attorney, the other sibling has an attorney. Those legal fees are racking up. It gets outrageously expensive. So that's why, one, you need at least a document like a will. At least do that for your family, because dying without a will, the only people that win are the attorneys. So heirship with or without administration is the legal process to determine who the heirs are, who are the people entitled to the property of the estate of someone who fails to leave a valid will or create another form of estate plan like a trust. Why should you avoid probate? It costs a lot of money. So number one, we all are concerned about money. None of us like to throw away money. Probate is sometimes, I feel, just throwing away money. There are legal fees, there are court fees, there are publication fees, there's often bond fees, there's accounting fees, there's the executor is entitled to a fee. It's extremely time consuming. The worst part about it, though, it's a completely public process, meaning everything that's filed into probate court is public record for anybody to read. So I tell people, okay, you want me to do your will? I'll write your will for you. Do you want to share that will with the world? And most people say, no, this is my own private will. The only people I want to share it with is my family. Some people don't even want to do that until they're gone. But I'd have to tell them, well, the minute you pass away and probate is initiated, I got to file your will into probate. So your will is the first document that everybody has the right to read. And during probate, your family is going to have to file an inventory telling the entire world what your estate has. So now the whole world knows you're dead. They know what your wishes are, and they know what you have. And so I always say, to me, that's the worst thing I could do to my spouse, because if I died with just a will, my spouse would have to file the will. Now everybody knows she's a widow. And then she files an inventory. Now everybody knows what she has. So if people know she's a widow and what she has, who reads public records? Not good people, bad people usually. So your predators, your creditors, your scammers, it opens the door wide open to being scammed. And so the probate process, not only the cost and everything else, but the fact that it's not private is horrible to me. Because every probate I do, I warn my clients, you're going to get a lot of junk mail, but you're also going to get scammed. And one of the big things going around right now is there's companies out there, excuse me, there's companies out there that will send letters to people telling them that they need to get copies of their deeds and all their records to their real estate, and they're going to charge them $127 to do it. And it's a scam. It's a solicitation. And it looks official. And I've gotten more of those clients calling me. Just this week, I had a client text me and send me a copy of that letter saying, "Do I need to worry about this? What is this all about?" And I said, "It's a solicitation. Throw it away." Because they had all her information, they had her address, they had her legal description on her house, they had everything, all because of the public process of probate. So that's why we want to look at doing a trust. People will ask me, do I need a trust? Or I hear this all the time. I've talked to other people. I've even had people tell me I've talked to other attorneys and they tell me I don't need a trust. My financial advisor told me I don't need a trust. My accountant told me I don't need a trust. And the reality is that's probably a correct statement. Not everybody needs a trust, but everybody pretty much can benefit from a trust. So it always reminds me of, I have two daughters. I have a 20-year-old and a 23-year-old, but as they were growing up, I loved when they would tell me, Dad, I need these shoes. I need these shoes for school. I absolutely need these shoes. And I kept telling them, no, honey, you don't need those shoes because you have 5 other pairs of shoes. I know you want those shoes, but you don't need those shoes. And so it's just a semantics of whether you need a trust or not. You may not need it, but you probably want it, because it will benefit you in many ways. So trusts have to be administered like a probate, but a trust is administered outside of the courts. So if we have a trust, if I pass away, my wife has to contact our attorney, has to go through the process of administering the trust. There's paperwork that may need to be done. There's some things that may need to be done to set up accounts or whatever. It may cost a little bit of money, but it doesn't usually cost nearly what a probate costs unless you're a multi-millionaire and you have to do tax planning and all that. But most people aren't, and most people don't have to go through that. But my wife goes to the attorney, they do the paperwork and they do everything they need. It may take a week or so rather than months and months and months that a probate process can take. So the trustee, there's 3 people involved in the trust. And I don't think I put that slide in this one, but there's 3 people involved in doing a trustor, a trustee, and a beneficiary. I always tell people, think of a trust as a treasure chest. I build my clients a treasure chest. Now that treasure chest can be custom designed for the client because no 2 clients are the same. No 2 clients have the same property. No 2 clients have the same family. No 2 clients have the same objectives or goals of what they want to do. So you custom design the treasure chest, and then you put your treasure in it. And the trustor is the person that puts the money in the treasure chest. The trustee is the person that manages the money in the treasure chest. And the beneficiary is the person that gets the benefit of the money in the treasure chest. So I get the question all the time, well, if I set up a trust, does that limit my ability to get my money and do things? And does it limit me selling my house? No, it does not. It doesn't affect it whatsoever, because when you set up a trust, you're the trustor, you're the trustee, and you're the beneficiary. So you're all 3 parties, so you can do whatever you want. So you can put into the treasure chest whatever you want. You can take out of the treasure chest whatever you want. I always tell people, though, if you have real estate, when you take it out of the treasure chest and you buy something new, you need to buy it and put it in the treasure chest. And you probably need to talk to your attorney about doing that to make sure you got the proper paperwork done, proper deeds done. But it's a very simple process once the treasure chest is built. Now, what else do you need to do other than think about all the things we've done up to this point and avoiding probate by doing a trust? You also need to do things like identifying the utility companies of a person that that passed away, turning utilities off or making sure they stay on. During a probate process, I typically tell my clients, you don't want to pay any bill whatsoever that comes in unless that bill it belongs to something that's going to get taken away or turned off. So they'll say, well, I'm getting all these medical bills from my husband. My husband passed away and they're sending me all these medical bills. And I tell them, do not pay them while we're going through the probate process. They have to file certain things in probate court if they want to get paid. But you do want to pay the mortgage if you want to keep the house. You do want to pay the loan on the car if you want to keep the car. And you do want to pay the utilities if you want to keep them on. So you pay anything that will be taken away or turned off. But all the rest of the stuff can wait. That's why it's really important when you go through probate, when you have to deal with it, that you have an attorney that is an expert in probate. The law has gotten so complicated that you don't want an attorney that doesn't do this on a regular basis. I'm dealing with one right now where one of the parties involved hired a firm, and nobody in that firm has done probate that I can see. And I'm dreading it because I'm going to be dealing with an attorney that doesn't really know what they're doing. And the attorney can make the process a lot more complicated than it needs to be. So hiring somebody that knows the process is very, very important. You need to look at, okay, what financial institution, what insurance do they have, what mortgage, what auto loans, what credit cards. That can get very tedious and it can take a while. Quite often when we start a probate, my clients don't know everything yet. They don't know what this person had. And I tell them, well, we need to start monitoring the mail. We need to start keeping track of everything that comes in. And that way we'll figure out what credit cards they have, that kind of stuff. If you do everything online, you need to make sure that somewhere someone can find out how to get online to figure out what you have. Because I have that all the time. My dad paid all his bills online. My dad had all his stuff online, but I have no idea what his login is, what he had or what he didn't have. And that makes it really hard because a lot of these online companies don't send mail. They're just doing everything online, and until it's like 6 months behind before they'll mail a hard copy letter to an address. And by that time, things could be taken away or turned off, or we could have issues like foreclosure pending, that kind of stuff. So again, the more organized you are and the more you leave that for your family, if something happens to you, the better it's going to be for them and easier it's going to be for them. So again, ultimately, the administration of the estate is gathering all the assets and debts of the estate. Now, as I've said already, that can be easier said than done. I was the executor of a gentleman's will years ago. I never I've never liked having the policy of being an executor for my clients. I don't like the potential conflict that could cause. But years ago, a very good friend of my family, his wife passed away and we redid his estate plan, and he begged me to be the executor because he said, if you're the executor, my family won't fight. If I appoint anybody in the family, it's going to be a nightmare. So I unfortunately agreed to do the executor job. When he passed away, it took me 3 years to figure out all the assets he had and all the debts he had. I had to hire companies to look for assets. I had to do so many things that shouldn't have had to be done because he was not organized at all. I remember getting the call from a financial person one time who was looking for assets for me. And he says, well, I think I've found the most valuable asset. And I said, what is that? He said, well, he had stock in Enron. And I had to laugh because if any of y'all are old enough to remember the Enron scandal, that stock wasn't worth the paper it was written on. So he finds this stock, and I tell him, well, let's get copies of the stock certificate because we may be able to frame them and they may have some value just as a stock certificate in a frame because they don't have any value as stock. So you never, know what you're going to deal with. And so again, more organized, the better, because gathering assets and debts is not always easy. Now, paying debts, you need an attorney who knows what they're doing because some debts get paid and some debts don't get paid. And people say, well, I've got to pay all their debts. No, you don't. You don't have to pay their debts because the law says this is what happens. The law says if a person dies, their debts die with them unless the creditor files a claim against the estate. Now, if the creditor doesn't file a claim, they don't get paid, no matter what. And if they do file a claim, they have to jump through certain hoops to be able to get paid. And even if the claim is accepted, they get put in line. And there's certain people that get paid before other people. And so number one, the government gets paid. So taxes, those kind of things, those get paid. The funeral expenses get paid, and the attorneys get paid. Those are kind of at the top of the list. Credit cards, way down at the bottom of the list. Hospital bills, all those things, they're way at the bottom of the list. So a lot of times there's not money to pay these debts, and so they don't have to get paid. So you need an attorney who knows what they're doing so you can monitor that and you do what the law requires as far as paying debts. Then once it's all said and done, if there's anything left, because sometimes it's all eaten up by fees and everything else, but if there's anything else left, it has to be distributed to the beneficiaries of the estate. So that's it. That's the end of this presentation. Let's see how we're doing on time. I kept it like right at an hour. So we've got about a half hour left to answer questions. And usually I find on this presentation, that's about the time needed because we have a lot of questions usually on this presentation.
You'll see there's a few already, but I'm going to answer the one about from Minnie. Yes, we do record these, and it should be available on our YouTube channel in probably a week. But we will also send out a second follow-up email to everyone who registered for this webinar that will have a link to the recording. Now that's not the first follow-up email that will go out tomorrow with the links to the slides and the survey. It's the second follow-up email, and that again will go out probably in 3 or 4 weeks. Can you touch? Okay, so there's a few. Please use the Q&A for your questions. That way, it's easier to kind of go through those than it is to do the chat. But I'll ask you, Fred. Somebody asked, can you touch on small estate affidavit?
Okay, very good. So that is one of the things that I didn't cover in this presentation, but thank you for asking that. A small estate affidavit in Texas is a special affidavit that is allowed if the estate is worth less than $75,000. And so that doesn't include the house. So if there's a house issue that can be excluded from that amount. Small estate affidavits are more difficult than they sound. A lot of people think, well, that's an easy thing to do and I can do it myself. And you can. Some counties actually, I think Dallas County you can call the probate court. They'll give you their form to fill out. And I send people down there all the time because sometimes the estate is only worth a couple $1,000s, for instance. I've had people that'll call and say, my son passed away and he has a bank account with $2,000 in it. What do I do? Because if I hire you, I'm going to pay you more than that to try to get this money. And so I'll send them to the probate court to do a small estate affidavit. But the courts are not real friendly in they expect you to know how to fill it out. And if you don't fill it out, you'll file it and you'll pay the court costs, which is usually give or take $300. And then if they reject it, they'll send it back to you, but they won't tell you what to do to correct it. So it can be kind of a pain. It is an option. It's not an option I like a lot, but I do use it. But again, the estate has to be worth less than $75,000, and you draft this affidavit. You sign it and file it with the court. The court has to approve it and accept it, and then if so, then you can present that affidavit to the bank or to whoever is needing it. One of the things I always warn people though about is before you go through the trouble of doing a small estate affidavit, you need to talk to the financial institution or whoever you're dealing with and make sure they'll accept it. Because you can go through all that trouble, get the small estate affidavit, take it to Wells Fargo, and then Wells Fargo says, no, we need you to administer the estate. We need letters testamentary. We need letters of administration. They won't accept it. And so I always want my clients to get approval from the financial institution before they ever consider doing that.
Brett, would you advance the slides? I want them to have your contact information.
Okay.
In case we don't get to everybody. If you'll advance that, and then we'll go back to there you go. If you leave it right there, and then we'll go back to the CEUs when we get closer to 11:30.
Okay. And
Go
just
ahead.
what did I do?
I don't know. You just
There we go.
there we go. Go ahead, and there's several in the Q&A. I grabbed that one right away. I'll check the chat if you'll start with the Q&A.
So I don't see, Marty, that I have. Where's the Q&A? Because I can see the chat, but I don't see the Q&A box.
You should. It should be along that same thing. Sometimes you might have.
Oh, there it is.
Ellipses.
I had to hit the more button to.
Yes, there you go.
Okay.
And you'll see. Someone asked about their sister owns a second home, and we could start from there. How's that?
Okay. It says my sister owns a second house in another state, which she wants to leave to me. What does she need to do to avoid probate in the other state? Very, very good question. That's why I love Q&A, because it makes me think of things I should have told you in the presentation, but I forgot. If you have property outside of the state, you have multiple probate problems. So if a person dies in Texas and they own property in Oklahoma or Louisiana or Arkansas or anywhere in the United States, you have to do a probate in Texas, and then you have to do what's called an ancillary probate in the other state. And so it gets even more expensive. The best way to avoid that with property in multiple states is to have a trust. So if they set up a trust, even if you set up a Texas trust, you can put non-Texas property into a Texas trust. And I'm doing it right now. I'm setting up a trust for a lady. She owns property in Louisiana. I contacted a Louisiana attorney who is going to draft me a Louisiana deed, deeding that Louisiana property into my Texas trust. And then that attorney in Louisiana is going to file the deed in the parish that property belongs in. And then it's good to go. The trust now holds all the property, and the trust says where the property goes. So in your situation, your sister's trust would say, I want my sister to have this property upon my death. And then upon your death, it transfers to you. Now, the cost of me getting a Louisiana attorney to do that deed is probably going to be less than $500. If I had to do a probate in Texas and then a probate in Louisiana, you're probably looking at $3,500 each state minimum. So it's a big price difference to do that. That's why I say so many people will benefit from doing a trust. Okay, second one, and what do I need to do to seamlessly inherit the out-of-state property? I think we covered that. If it's in a trust, it'll automatically transfer to you upon your sister's passing. If my parents die here in Texas, no will prepared, 2 kids from the marriage, how and what they should do to put the home and they're in their names or to sell the property. Okay. If parents die and they have children of this marriage, just this marriage, not children outside of the marriage, then the law still says that when spouse number one dies, all the property goes to the surviving spouse. When surviving spouse dies, all the property goes equally to the children. Now, in order to do that, though, that means an heirship proceeding has to be done for each time. When spouse number one dies, there's an heirship proceeding to transfer property to the surviving spouse. When the surviving spouse dies, we have to do an heirship proceeding in probate court to transfer it to the children. Once that is done, then the children have the property in their name. They own it equally. So let's say we have a house and we have 4 kids, or in this case, we have 2 kids. Okay. So we have a house. Now the 2 kids own that property 50-50. That means they have to agree if they want to sell it. We have problems if one wants to sell and one doesn't want to sell. And so transferring property like that, it can be done rather seamlessly, but problems can happen if families don't get along and don't cooperate. But that's what would need to be done, is an heirship administration or an heirship with administration when spouse number one dies and when the spouse number two dies.
Yeah. What if they, Fred? What if they didn't do it with spouse number one and it's been many years? In other
Very
words, what?
good. Okay. If spouse number two dies, but nothing was done when spouse number one dies, something now has to be done, because a lot of people, and this, I see this all the time. My dad passed away in 1995, and my mom has lived in the house ever since, and she didn't do a probate for my dad because she didn't think she needed to. And now mom's passed away. Well, now we have to do a probate for dad, we have to do a probate for mom, and we have to get it transferred to the kids. Now, there is what's called an affidavit of heirship. An affidavit of heirship is where we get 2 disinterested witnesses to sign an affidavit about the family. And these 2 disinterested witnesses have to know a lot about the family. They have to know my dad, who my dad's parents were, who my dad's siblings were, who my dad only had this one marriage. My dad didn't only have these 2 kids. He didn't have any kids. So there's a lot to that affidavit that they have to sign. Now that affidavit gets filed in the deed records and it transfers dad's interest to mom. Now, I do that quite often when this happens. Sometimes I don't recommend it because affidavits of heirship are not automatic proof that it belongs to mom. It can be challenged for 5 years. So it, I always tell people, if you're not going to sell the house right away, then maybe an affidavit of heirship is not the best way to do it. We may just go ahead and do an heirship for each mom and dad. So it really depends on the family and the situation. But that is one option, is an affidavit of heirship rather than going through a full-blown heirship with administration. Okay, next question. Should IRAs, 401ks, etc., be renamed for the trust, or is it sufficient to name beneficiaries with the financial entities where those accounts are? Now, retirement accounts like IRAs and 401ks, you do not want to put in the name of the trust. They have ultimate protection when I own it. So if it's my IRA, my 401k, if somebody sues me, they can get certain things from me, but they can't get my retirement account, they can't get my house. So we leave it in the name of the person that owns the IRA. Now, if the person who owns the IRA is married, we often want the spouse to be the number one beneficiary. Because if I die, my IRA isn't inherited by my wife, it becomes my wife's. So my IRA becomes her IRA. And then we list the trust as a contingent beneficiary. So it goes from me to my wife to my trust for the benefit of my kids. So you typically want to list the trust as a contingent or secondary beneficiary on IRAs and 401ks. My husband and I have a will. We have a timeshare in Tennessee. How does that work? Would it be considered real estate? Would it best be in a trust? We have 3 adult children and 2 grandchildren. timeshares are funny because sometimes shares are owned by deed and sometimes shares are owned by contract. And so you need to figure out how the timeshare is owned. But yes, it is still always better to have a trust and to have the timeshare owned by the trust for the benefit of your children, because the timeshare can cause a probate problem. But that is one of those that you need to figure out whether it's a contract or a deed. And if you want to talk further about that, that's why we put my contact information. I'll be more than happy to walk you through it and talk to you over the phone about it, and what you need to do to better to take care of that. But
One thing
short
I need,
answer, yes, the trust
Fred,
works.
I need to very be careful. You can contact an estate attorney um 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 to help you with that, right? I've got
Yes.
to add that. I've got to say, you could, obviously Fred is a state attorney, but there's other state attorneys out there, and um um you just need to contact one to help you with that.
Well, and thank you, Marty. Because yes, I always tell people, please, whenever you're doing any of this, make sure you get a reputable state attorney to help you with it. Now, we put my contact information on here because I answer questions for people all the time, and I don't charge for that. This is not, you're not hiring me. I just want to be a resource. And so if somebody needs to call me for a resource, I'll be more than happy to help you with any of that. And I'll quite often I'll direct people to estate attorneys where they live if they're, not in this area or whatever. And I'm a member of what's called Wealth Council, which is state attorneys all over the United States. And so if you're in a different state, for instance, and you say, well, do you know any estate attorneys in Wisconsin? I do. So you could call me and I can direct you to an attorney that knows what they're doing. Be more than happy to help in that regard. Um, Please share where the best place to gain this information in your specific state or province if you're international. Thank you for sharing the incredible knowledge. Okay. That's not an easy answer because there's not a one size fits all place where you can go locate this information in your state. Each state has an estates code or something like an estates code, but unless you're a lawyer, you're not going to understand it because it's all written in legal language. Um, but it's best to find somebody in your area that is known for uh, working in this area of law exclusively, and talking to them. Again, if you're needing somebody in a specific area, I can direct you to an attorney in any state in the United States. Internationally is a little harder. I do know some Canadian attorneys, but I don't really know a lot of attorneys in other countries. But I can direct you in the right direction if you want me to. Can you provide? Let's see where can you?
The phone number should be on the screen. If not, uh, Fred's contact information will be in the presenter's contact in the follow-up email. So if you don't get it here, but you should be able to see his phone number on the screen now.
Okay, so another question is, besides a trust, what's another way to avoid probate? Again, going back to that screen, I said the state laws dictate and the type of property. In Texas, you can avoid probate if you own only property that passes outside of probate by way of beneficiary or TOD or POD. And there is a way to do a deed to transfer a house outside of probate, which is called the ladybird deed. Now, a lot of people ask me about the transfer on death deed, and I'm not a big fan of it. I already told you that. But the ladybird deed has been around a long time, and it is usually used to pass a house outside of probate so that Medicaid can't attach to it. It's kind of a legal loophole that's allowed to transfer a house. So sometimes what I'll do for people, I'll give you an example. I've got older people that they have a bank account. They may have one financial account, but they really are down to being very simple, and they own a house. And for those people, we'll set up a will and living documents, because everybody should have a power of attorney, a medical power of attorney, a medical directive, a HIPAA form, all the documents you need so that somebody can take care of you during your life. If you get sick, they can make financial decisions for you. They can make healthcare decisions for you. So I'll set that up. I'll tell them, okay, on your bank accounts and your financial account, either list your children as the beneficiary or put them on the account, depending on what the situation is. And then we can do a ladybird deed transferring your house to your kids upon death. And what the ladybird deed does is it says, I own the house during my life. I own what's called a life estate, and I can do whatever I want with it while I'm alive. I can even sell it. But when I die, it automatically transfers to my kids. So it transfers outside of probate without having to use a trust. So that is another option. Is a will invalid if you have no witnesses, but it is notarized? Yes, in Texas it is. Texas wills require 2 witnesses and a notary. If you have a Texas will that is only notarized, then it does not meet the requirements of Texas law. I often get the question, can you do a handwritten will in Texas? Yes, you can do a handwritten will in Texas. It does not have to be notarized. It does not have to be witnessed. But it has to be exclusively in your handwriting. It cannot be typed. It can't be in somebody else's handwriting. It has to be 100% in your handwriting. They're called holographic wills. I have probated holographic wills, but they always cause problems, always, because they never have all the detail that you need. But typically it's when somebody is dying and they're in the hospital and they just want to write down, this is my last will and testament, and I want everything to go to my kids, and I want my son to be the executor. And that if it's written in your handwriting and it's signed by you, it can be a valid handwritten will. But if it's a typed will and it's not witnessed, then it does not meet the requirements of Texas.
Fred, would you back up one? There was one that you missed about templates for wills and trusts.
Okay. Oh, is there a place where you can get templates? Yes, they're all over the place. Do I recommend them? No, I do not, because you don't know what you're getting. There are laws that basically protect the businesses that put legal documents on the web and don't protect the consumer. And what I mean by that is, in Texas, there is a law that says if I am providing legal documents on the internet, as long as I put a disclaimer that I'm not providing them as a lawyer and as a law firm, then I have no liability whatsoever. Meaning, you buyer beware. You get what you get and you don't know if it's right or not. And so it is way, way too risky to use templates that you find either in a Office Depot or you're provided by, I think Susie Orman does stuff, all these people that provide things that are not attorneys. You don't know what you're getting, and you don't know if it is good, and you don't know if it meets the requirements of your state. I am one of those who loves to save money. I'll do everything I can to save money. This is not an area you want to save money in. This is an area where you want to do it right. So you want to spend a little bit of extra money to make sure you go to somebody who knows what they're doing to do it right for you. Because if you don't do it right, you find out it's not right when it's too late. So if you buy a will and it's terrible, your family's going to figure it out after you die, and then they're going to have to go through a bunch of headache and all. And I tell people I make money. The lawyers make money cleaning up messes. They don't really make money doing this right. So doing it right in the first time may cost you a little bit money, but that's not where they make their money. I already told you, I'm the administrator of an estate right now. My legal fees are well over $15,000. That's ridiculous. And it's all because we're cleaning up a mess. So I'm going to get off my soapbox, but please spend the money to do it right the first time so that you're not having to put your family through problems. Do the laws vary from state to state? Yes. Every state is different. Estate laws and will laws and trust laws are state by state by state. Quick example, my uncle was in Wisconsin. He got diagnosed with cancer. I went up there to see him. I asked him if he had his documents, and he didn't. He wanted me to draft them, but I told him I couldn't because I'm not a Wisconsin attorney. I got a Wisconsin attorney to do his documents. Out of a courtesy, he sent them to me to review. I called the Wisconsin attorney and I said, I have to trust you because these don't look anything like Texas documents. So I got to trust that these are Wisconsin documents because they don't look anything like ours. And so that can be that different. So every state is different depending on, and that's why you need an attorney in the state you live in. Did I miss any? Let's see, where are we?
There should be at Helen. We've got 16 that are still up.
Okay, what if real estate hasn't been probated since the death of parents, original buyers? If the deaths were years ago, will the probates need to be done? Yes, I think we've already answered that. Yes, a probate or something like it, like maybe an affidavit of heirship, but something needs to be done to clean up title to the house. One of the things people don't think about in Texas and they don't realize in Texas is that when a person dies, their interest in real estate goes to the grave with them until you take it out of the grave. And so no matter how many years ago they died, they still own that property until you do something legal to transfer it. What qualifications should I look for or ask about when hiring an attorney to set up an estate? Does this attorney do estate planning as their primary practice? Law has become like medicine. I'm not going to go to a brain surgeon to have my heart worked on. I'm not going to go to a heart surgeon to have my colorectal issue taken care of. We go to gastrologists, we go to cardiologists, we go to these doctors who specialize in certain parts of the body. The law has become the exact same way. I don't do anything but estate planning, probate, guardianship, and elder law. That's it. So people will call me and say, hey, can you help me with my divorce? No, I don't do family law. I don't do bankruptcy law. So you want to make sure that you find an attorney who this is all they do, and this is the area that they know very well. And then I tell people, there's two things. You need to like the attorney and you need to trust the attorney. And if you're not comfortable with that, then go to somebody else because you're going to need to feel comfortable with them. You're going to spend a lot of time doing stuff with them. And you need to trust that they know what they're doing and that they're going to be honest and ethical with you. And if they don't, I've told clients that. I had a client one time who I'm asking her questions and I said, do you have a 401k? And she said, yeah. And I said, can you tell me roughly how much is in that account? And she says, no, I don't want to disclose that. And I said, then you need to go hire somebody else because if you don't trust to give me that information, then I can't help you because if I don't have the information, I can't protect you. And so if you're not comfortable giving me that information, you need to go find an attorney you're comfortable giving it to. And so you need to like and trust the attorney you're going to. If you have a joint tenancy with right to survivorship and you have a stepchild, do they still have a right to the property? Typically not. Typically, they only have a right to property if they're a biological child or their adopted child. So stepchildren don't usually have rights unless it's specifically written in there. Okay, POA is no longer valid upon death, regardless of the state you reside in, correct? Now, I can't answer that because I don't know what other states do, but I would guesstimate that that is true. I can't imagine a state allowing a power of attorney to continue after death because that's not the purpose of that document. The person would need to be named as the POA in the will. Okay, so they're not named as a POA in the will, they're named as the executor. So executors are people that carry out the wishes after death in a will, or a trustee carries out wishes in a trust after death. So yes, you need living documents and you need death documents. What is the maximum age for giving away organs, or is there a maximum age? Well, I'm not a doctor, but I've been told there is always something they can use. No matter how old you are, no matter how frail, no matter what. there's always tissue or certain organs or something that they can harvest from a person. So if you want to be an organ donor, age is not an issue. They will take what they can, what they can. And you're never too old to donate your body. My daughter is in her first year of medical school at the University of Auburn down in Alabama, and she is in anatomy. And she called me very upset because they got assigned their cadavers. So people donate their bodies to medical school so medical students can learn from it. And the body that my daughter got was of a very old lady who passed away from dementia. And it bothered her because it reminded her of her Grammy who passed away this year at 93. So you're never too old to donate if you want to donate. What is the cost for a trust creation for the average American? Okay, I'm gonna first give you an attorney answer because that's a very difficult question. That's like somebody walking onto a car dealership and saying, "How much is a car?" Well, what kind of car do you want? What kind of car do you need? What are you looking for? What amenities do you want? A lot of questions go involved, but I can tell you a good trust by an attorney who knows what they're doing, I would guesstimate 2,500 and up. I mean, most of my trusts run from 2,500 to 8,500, give or take, depending on what somebody needs. So but the cost of probate, we already said, is $4,500 and up. So a trust, even if you're paying the same cost as a probate, a trust for a married couple avoids two probates. So you're saving, $10,000 in future legal fees, and you're setting up a $4,000 trust or whatever, So that's why I say it's worth doing it right. Expect to pay a little bit for it if you want it done right, but it's worth every penny. What is the estimated cost of doing a trust? Already have, what is that? Already have a will. Okay, it's the same because whenever you have a will and you do a trust, you're basically replacing the will with the trust. So you're setting up a new trust and then you're getting rid of your old will. My mother died August 2024. I had not thought about filing probate since we did probate when my father died in 2007. We moved mom to an assisted living, and then after years of slowly progressing Alzheimer's, I moved her here to Mesquite, where I have lived for 30 years. When COVID hit, the director of the facility called me to ask if it was okay to move her to their Medicaid facility, and I said yes, since I do not have access to one of the latest annuities pensions. I was referred to an elder law attorney if I wanted help filing with Medicaid, which I did. So I think all her assets were accounted for during the process. Were they not? Probably, but I don't know the answer to that without knowing all the details, more details. I did have an account for $2,000 from the pension, and they were still being sent to the nursing home. Mom and dad did their last will and testament, and I think a living trust was done. If your mom was on Medicaid when she passed, and the bank account that has the 2,000, less than $2,000 in it, if you were on that bank account or if the bank account had a beneficiary, the most likely answer is that you probably don't have to do a probate. That was my mom. I had put my mom in a nursing home and on Medicaid, and when she passed away, I was on the bank account, so that money became mine. And the only issue we had was after she passed, I got a refund check from the nursing home, and they initially gave it to me in the estate of my mom's name, which would have required me to do probate. And instead, I went and talked to them and I said, hey, can you reissue me that check in my name, or at least just put it in my mom's name and I'll deposit it into her account? And so that's what they did, and we were able to avoid probate. So most likely you don't have to do probate unless there's any other assets out there that you're not accounting for. So I don't
But
think you do.
but I'm going to say it's important to say that the details that Fred's answering the question under are just the details here, and if there's more to it, you really might be advised to talk to an attorney. It's just hard to give legal advice, final legal advice for you to take from here, um, with a paragraph of information. Is that
Yeah,
fair enough to say?
that's
And
exactly
you
right.
need
Thank you. Yes,
I'm just trying to make sure we're not, we're here to give you general legal information. We're really not here to give you case specific information, just because you'd have to become a client to do that. So
that's right.
go ahead.
So
I'm sorry.
Marty, I just noticed it's 11:30, so I don't know if you want to
Yep,
back up
I do. I
and
do.
talk about the CLE before we,
Yes,
so if
thank you so
anybody
much.
wants to get off.
Thank you, Fred. Hey, since it's 11:30, so we're going to go ahead and talk about CEUs real quick. For those of you joining us for CEUs or for a certificate of attendance, we're providing complimentary CEUs for licensed social workers and licensed professional counselors in the state of Texas. Also, the certificates of attendance. If you have a different license in Texas or a license outside of Texas, feel free to go through the process, get a certificate, and submit it to your jurisdiction. But please note there's no guarantee that they'll take it. I have had people that have told me they've been able to use them. I have had jurisdictions reach out to me for more information on a webinar we've done because someone submitted them a CEU certificate just to see if the curriculum met their standards. Today's webinar is worth 1.5 hours CEU credits. You must complete the entire webinar and the live Q&A up till about 1 minute ago in order to qualify. You must complete the Google evaluation survey. It will pop up as you close out of Zoom, most likely. Some companies have pop-up blockers that will not allow it, but it should pop up as you close out of Zoom. It should just say, would you like to take a short survey? It is a very short survey, but it's required if you would like a CEUs. If it doesn't pop up, do not worry. It will go out in a follow-up email, most likely tomorrow to you. And the handout and the link to the handout and the slides, I've put them in the chat a couple of times, but those will also be in the email as well. We will have the recording of the video will be up on our YouTube channel within the next 3 to 4 weeks. So look for that. And then after that, you'll get a second follow-up email that gives you a direct link to to this specific recording. The Google surveys will be available till the 7th of November, and then give us about a month. Actually, we're even farther than that behind right now, but give us a month and a half, and we'll get the certificates emailed to you. They will go out by email. Thank you, Fred, for remembering that. You can go ahead and put it back where it was. And if you have time, I don't
Yeah,
know
I
if you
can.
have time, Fred, that's up to you.
Yeah, I can answer a few more questions. So let's do that before we jump off. My mother never remarried. What happens to her IRA from employment when she passes? Do the children inherit the monies? Okay, now retirement accounts, like any other financial account, they pass by way of beneficiary designation. So you need to see what your mom, or you need to talk to your mom about whether or not she's updated her beneficiary designation on her retirement accounts. So you'll hear the term TOD, transfer on death, and POD, pay on death. But whether they use the term beneficiary, TOD, or POD, it all means the same thing. But again, that has to be done by your mom with the financial institution that holds that money. Now, if your mom did not list a beneficiary and passed away, then that money goes into the estate and causes a probate problem. So that's why it's important to talk to the financial institution to make sure your mom has it set up the way she wants it and it passes to the people she wants it to pass to. My dad passed away without naming an executor in the will. However, he wanted the family home to be left to the 8 heirs. 3 of the 8 want to sell. Let me see if I can scroll down. 3 of the 8 want to sell, and the 5 heirs do not. Oh, this is a fun one. One of the 3 heirs went to an attorney and made herself executor and notified the 5 heirs afterwards. To keep down further tension in the family, we canceled court date to challenge. Okay. I'm not sure what I'm wanting to answer there. That is a typical example of when a person passes away and the documents aren't in place properly, and you have multiple heirs that don't agree with each other. It can be a mess. But if the heirs have agreed to let this child be the executor, which they're probably the administrator in an executor and an administrator, same job, they're just different names for different things. Then that person probably has the authority to do what they want, and the others are going to have to live with it. So if
Yeah.
you, what I often have in situations like this, and I don't do contested probates anymore. I used to. I did family fights like this, but I wouldn't do it anymore. But what you often have with situation like this is where some want to sell, some don't. Then they have to file a lawsuit called a petition to sell, and they have to ask the court for permission to sell the property and divide the assets. So it gets really, really nasty. And it, again, the only person that wins is the attorneys.
Fred, one of the experiences I've had um, with my in-laws from my ex-wife was that um, joint interest, undivided interest in a property is a nightmare.
Mm,
Undivided interest, because everyone, I don't know how many heirs you have, but every one of them are in a different situation, both financially, have different, and putting them in a position where they're just totally just creates so much tension in a family. It's crazy. Once you divide up or force the sale, and obviously the ones who want to keep it have the right to buy it
mhm.
if they would like. But I don't know what your experience is, Fred, but I've had
Oh,
quite an experience with that, and it's been a nightmare every time.
it is. Not 99% of the time, it's a nightmare. I actually have one right now that the family has agreed to give a piece of property to one of the children. And I think there was 5 children involved and a stepmother involved. And everybody's in agreement, which is shocking to me. And even that, she's having to pay me $2,500 to do all the deeds, because there's like 8, 9 deeds I have to do so that we properly document who's giving what interest to what person. And so it's never a good thing. It really isn't. And so when I help people set up estate plans, I talk to parents and I say, do you really want to leave your house or your property to your 5 kids equally? I mean, you know what kind of a problem that might cause.
It is
Well,
a
my
huge.
kids all get along. And I'm like, yeah, they do until the time comes, and then they don't.
Yeah.
And so we're all dysfunctional at some level. It's just some families more so than others. And the more dysfunctional a family, the more attorneys make. And I've always told people I don't have to look for business to make money. There's so much work out for an estate attorney to do. 70% of the population doesn't even have their documents in place. So 70% of the population needs somebody like me, or there are people like me that'll clean the mess up when the 70% doesn't do what they're supposed to do. So there's no shortage of work. So please don't do us a favor. Do your family a favor and do things right so that you can, save problems.
Every one of the kids is going to be in a different financial position. Some of them are going to need the money and need to
Yep.
get out. Other ones are not going to need the money and want to hold on to it for posterity purposes or whatever. and it just is, I can tell you, it is a nightmare just waiting to happen.
Yes, it is. So, for a small estate, would a ladybird deed to handle the house and a small estate affidavit be sufficient to avoid probate? That's kind of a funny question because you don't do a small estate affidavit until after a person dies. So you do a ladybird deed before they die, and a small estate affidavit is something that's determined whether we need it after they die. So if it's a small estate, typically you can use a ladybird deed to pass the house, and then you can do beneficiary designations on any accounts or whatever to pass the money if there's bank accounts, checking accounts, something like that. Um, there are ways to set up that it passes outside of probate without having to do a probate. Is legal Zoom legit? I love that. Yes, they are legit, and they're probably one of the biggest ones out there. Um, do I advise my clients consider doing it? No, I do not. LegalZoom has gotten better, but they are a California company and they claim to have attorneys that do documents all over the United States, but there are always problems with them. Again, they have no liability. They're, if I do documents for somebody, I am held accountable under my license with the State Bar of Texas, and somebody can sue me, and that's why I carry legal malpractice insurance, and somebody can file a grievance against me if I don't do my job. You can't with people like LegalZoom. They are a company who provides a product. And as I was told one time, because I thought about setting up my own website at one point to do that, and they said, in Texas, there's a law that protects these companies, and as long as they have a disclaimer, and if you go onto the LegalZoom's website, you'll find their disclaimer somewhere in there saying they're not a law firm, they're not a substitute for legal counsel, and as long as they have that disclaimer, they have no liability. And so it's like you purchasing a pin. If you buy a pin over the internet and that pin doesn't work because you tried it and it didn't write, then you can send it back and get another pin maybe. But if you buy a will, you don't know that will doesn't work until it's too late. So I never ever recommend people do the internet. I had a gentleman call me one time and he said, "How much is a will?" And we talked about it. And he said, I could do it cheaper on the internet, couldn't I? And I said, "Yes, sir, you sure could." And he says, "Well, you can't tell me that you don't use forms to fill out your documents." And I said, "No, sir, of course I use forms. I don't rewrite it every single time I do it. I don't have the time for that. So yes, I use forms, but I can tell you, I know how to fill the forms out. Do you?" And he paused for a minute and said, "When can I come see you?" And that's another one of the big problems is these companies expect you to fill the forms out. And if you don't fill them out right, that's not their problem. It's your problem. So yes, it's a legitimate company. No, I don't recommend it. What about the wills on the Tex Government website? Okay, same thing. They're no better. Just because they come from a government entity doesn't mean they're better documents. They do probably have the minimum Texas requirements in them because, for instance, a statutory durable power of attorney has minimum requirements. And if you put only the minimum requirements in there, it's about a 3-page document. But I don't know a financial institution that I deal with that wants the minimum requirements. They want more than the minimum requirements, and they can demand that. So my powers of attorney are 10 to 15 pages long because I want to make sure that when my clients use that document, they're not going to have a problem. So if they have to say, "Oh, wait a minute, mom's in a nursing home. I need to sell mom's house so I can pay for her care." I want to make sure their power of attorney gives them authority to sell the real estate in that situation. If they need to access mom's 401k to pay for her care, I want to make sure the document covers that. And the minimum requirement documents put out by the state don't do that. So you want more than that. I
Oh,
accidentally
actually,
got, oh,
I'm sorry. Go ahead, Fred. I'm sorry you were done.
I think somebody accidentally got out for 60 seconds. They got back
Yeah,
in.
that's what I was going to answer real quick. For those of you that join us on any of these Zoom meetings, just so you know, Zoom tracks how many minutes you're in for. But if you get knocked out and sign right back in, it just starts a new account, and we add those together when we get to the point where we're doing CEUs. So it's not a problem if you get knocked out and have to log back in, as long as you're not gone for 30 minutes or something like that. You should still not see any problem getting your CEUs. Thank you.
Okay, so I see a lot of the same type of question basically
Yeah.
is what about the forms put out by the Department of Human Services? Again, they're better than nothing, but they're not the best documents you can get. So it just depends on what you want. If you want to be, settle and just do the minimum, and then hope they work, great. But I get more and more people call me than you can imagine saying they had those documents and they had problems with them, or and the problem is when you have problems with them, it's probably too late. Well, mom did this document and now mom is in memory care because her Alzheimer's gotten really bad, and they're not accepting the document. What do I do? Well, mom can't do a new document now because mom's mental capacity is not able to do a new document. She doesn't understand it. So what is our choice? Our choice now is guardianship. And guardianship is outrageously expensive. You're looking roughly around $7,500 to do a guardianship, all because mom did substandard documents. So that's why I'm saying it's not worth saving money. It's better to do it right in the first place and have it when you need it, when the time comes. My husband has an adult stepdaughter from a previous marriage that he did not legally adopt, and a biological son from that marriage. Can we treat the two children as equals in our trust and other legal documents? Of course you can. You can treat people any way you want to in a trust or documents. That's the good thing about it, is if the law says a stepchild does not inherit. Your trust can say, yes, that stepdaughter is just like the biological, and we're going to treat it as our child. So yes, most definitely you can do that. You can give money in trust to anybody. I mean, you can give it to charity, you can give it to churches, you can do all kinds of stuff with a trust that you can't do just through the law. Can you discuss inheritance in patients? I'm not sure what that is. I don't know what that term means. Is this something that you see? Inheritance in patients?
I've never heard of it,
I've not heard what that term is.
but
Um,
I will Google it as you go to the next one.
okay. I want to donate my organs upon my death. What is the best way to ensure this happens? There are, depending on what you want to do, if you just want to be an organ donor, typically you can let the Department of Public Safety know and they will put it on your driver's license. But I do forms for somebody called an anatomical gift form. And when I fill out all the rest of their documents, they fill out this anatomical gift form saying, I want to donate my organs, I want to donate my tissue. You get to specify exactly what you want to do. Are you donating just for transplantation purposes? Are you donating for medical education or treatment or therapy? It gets real detailed in what you want to allow happen with your organs, and so I recommend that type of form. It really helps them know what you want, especially if you're wanting to donate for your entire body. If you're donating your entire body, there's medical schools, or like in Dallas area, you can what is it, the Southwestern
Medical school, University of Southwestern, UT Southwestern Medical
UT
School.
Southwestern, yeah. And they take bodies for education and that kind of stuff. So there's different avenues you can look into depending on what you want to do.
Fred, I just put in the impatience in the chat. Oh, let me see, make sure I hit return on it. But it's really just when kids are trying to get their parents' money while their parents are still alive because they think they're entitled to it.
Yeah,
And
do I see that a lot? Yes, I do.
yeah,
And I have to. Oh, I've gotten so mad at children before, and they come with their parents to do their estate plan, and I've made children leave because I'm like, no, this isn't about what you want and when you want it. This is about what your parents have and what they want. So yes, greed is a very, very powerful sin. Um, and let's do this last one, and then if there's any other questions, people can reach
Got
out
it.
to me.
Yep.
If my husband has an old trust from before our marriage, 15 years ago, for his adult son and his adult stepdaughter, and he has never shown it to me, is it still effective? Yes, it is. It is still effective. Despite our marriage and move since then, yes, it is still effective and is still good. He can control, in Texas, you have the ability to control your own separate property. So separate property would have been any property he brought into the marriage that he had prior to your marriage. And he can control his half of the community property. So he does not have to do a marital plan or a marital trust or a marital will. Um, if he does something like that, it voids what he did before. So I do that all the time. I'll have people that'll have their own solo single trusts, and then they get married, and we do a marital trust. And the marital trust will take place of the single trust. So it really depends on what he has done. But if he hasn't done anything, then that trust is still in effect.
Um, Even though they've done a will, she has here at the end that I believe the person says that they've done a will once they got married.
Okay.
The trust, the premarital trust will still take precedent.
Okay. So yes and no. Um, again, let's think of a trust as a treasure chest, and the trust property has to be aligned with the treasure chest. So let's say I have a piece of real estate and it's in the name of my trust that I had before I got married. If I did a will saying any real estate that I have goes to my wife, but that trust says that that real estate goes to my kids, the trust is going to prevail because the property is in the name of the trust. And wills do not control trust property. They only control what's outside of the trust. So there can be a time where both the trust and the will dictate depending on the status of the property. Does that make sense? I hope.
Yep. Fred, thank you so very much.
No, my
Once
pleasure,
again,
Marty.
just
I love
it
doing
really
these things.
incredible. Thank you, thank you, thank you. And you've been so generous with your time. I mean, it's almost, it's almost 12 o'clock. I sincerely appreciate it.
Oh, my pleasure, Marty. Thank you for allowing us to do this. I love educating. I hope people got a lot out of it. If anybody has any questions of either Marty or I, you guys have our information, and we'll direct you in the right direction. But God bless you all and everybody. I hope they have a great afternoon.
Yeah, look forward to the follow-up email. It will have Fred's contact information in it, along with the slides and the handout. And if you didn't open the handout, I highly recommend you open the handout. It's very valuable information that you would probably want to have somewhere for when the time comes. You'll find it incredibly helpful. But thank you all
Marty,
for joining.
real
Go ahead.
quick though, did you have another webinar coming up that you wanted to share with anybody yet?
Um, you know, off the top of my head, I can't tell you. I've got to get set up with you guys. I usually what I advertise is the next one that I have coming up with you. And, and,
Okay. I just
and
didn't know if you had one for November or December you just wanted to tell people about.
well, I mean, there's a couple of things that are coming up with November. We've got one on legal documents that's coming up in November, and we've got one on that's going to talk about changes in the law. But it's really going to be an opportunity for you to ask the attorneys questions. There's going to be a short presentation, but you're going to have a lot of Q&A time to
Awesome.
ask the attorneys questions about changes in the law and how those might affect you and that kind of thing. So,
Oh, that's awesome. Yeah.
those will be coming up. So, and then I'll get with Jennifer and work out if what we do next, I just haven't done that yet.
No,
And so,
that's fine. We'll see you the first of the year.
or that would be the slot I would have. Very good. Thank you again. Thank you so very, very much. And thank you all for joining us. And you all have a great day.
God bless everybody. Take care.
Take care.
Bye-bye.
Bye bye.